Gretchen Tallman, and today I'm going to be speaking with Mary Frances Coleman with Thompson Law about what a homeowner can expect when they come in for a consultation to discuss the possible short sale of their property. So Mary Frances, can you please give us some details?
Sure, Gretchen, thank you. Thanks for coming in. Typically, when I meet with a homeowner about a consultation regarding a short sale or the liability issues surrounding with them, we go over a whole checklist of items that as the attorney I find it necessary to make sure that the client understands what the potential pitfalls and ramifications are. So what we usually start talking about is the choices that the homeowner has in regards to the distressed property itself. And sometimes I do say that you might not have a good choice, but you're going to have better of a bad choice, and we need to weed those out and see what works for the homeowner. So I usually go in a logical legal order, and what I talk about and discuss with the client would be starting off with the actual property, which property we're talking about, how many loans are on it, when they acquired the property, how much it was worth, or how much they paid for it when they got it, what loans were originally on it, and were they refinanced, how they were refinanced, if they took more cash out, and through those questions, and we have clients fill out a questionnaire prior to coming, but I always verify those questions, and through those questions then I can establish where we stand presently. I don't know, I can't give advice on where it is today if I don't know what happened previously.
Okay.
So I ask the client that question, and more importantly what I ask is what the estimated value of the property is today. And sometimes clients come with a realtor who already has done comps or done some sort of investigation on the value of the property. But the value of the property today is really paramount information. Otherwise, I can't use the numbers or the examples with the client themselves. So we start there.
Okay.
And then we go forward about what those loans mean. Meaning, what would happen if you stopped paying your mortgages if you haven't already done so. Many times clients have already stopped paying their mortgage or mortgages if there's two loans. So we move forward and what happens next in Arizona, what the process is. And typically what I discuss is that there's two kinds of foreclosures in Arizona. A lender has the right in Arizona to, if you have a note in a deed of trust, which is the vehicle through which most loans were acquired and properties were acquired in the past 30 years. But if you have a note in a deed of trust, a lender can foreclose on that property if you have not made those payments in two different manners, which is surprising to a lot of people. Most people understand the trustee's sale. They hear that. They call it an auction or a trustee's sale. That's a non-judicial foreclosure. But we also have judicial foreclosure in Arizona where the lender can actually file a lawsuit and ask for the property back. And sometimes in that lawsuit they can apply for and get from the judge a deficiency judgment at the time. So we'll go over the differences between there and what it means for the homeowner if the property goes to foreclosure. Then we kind of switch gears to the short sale and talk about the statutes in Arizona that may or may not protect the homeowner in a foreclosure, how they don't really apply to short sales. So we have to look at case law in short sales, and we also have to consider back to the beginning, the original information, what kind of loan you got and had you refinanced it, what type of property it is. All of those factors weigh in on how we can negotiate a deficiency release in a short sale, or if the homeowner might be liable if we don't get that specific waiver language after a short sale from a bank.
And that's really critical.
It's very critical because that's where things kind of get messed up. And there's a statute of limitations through which a bank can pursue a homeowner after a short sale. So all those things have to be very clear and understood by the client that we don't know until we're at the end of that short sale type of negotiation.
And that can be a long process.
It can be a long process, and we don't even know how it's going to end up until we're there.
Okay.
So we talk about those. We talk about the homeowner's obligations to the property during this whole period of time, because that has some contractual effects on the homeowner. You must maintain the property, pay the HOA, that's a personal obligation. The taxes, the insurance, all of those things.
So even if my payment includes taxes and insurance, if I'm not making my payment, the lender's probably not going to be making those payments either.
And sometimes that's very much the case. So
Yeah.
we have to make sure the homeowner understands that.
Okay.
And then we also talk about potential credit implications and potential tax implications, although I'm not a CPA, I'm not a tax attorney, and I'm not a lender. So I always encourage the homeowner to make sure that they've spoken to those professionals in addition to their realtor about everything that we're talking about as far as liability goes.
So this is a very detailed process.
Very detailed.
This isn't just a, I'm going to turn the keys in and walk away and I'm
No,
done.
it's not that easy.
Yeah, okay.
And also the consultation's not a half hour or 45 minutes. I'm not going to ring a bell and say ding, you're up. I'm there until the questions are all answered and the homeowner has a good idea when they choose which route to take, what could potentially be a liability to them in the future.
Awesome. Well, thank you so much, Mary Frances. That's very helpful, and I hope you all find the conversation with Mary Frances just as helpful as I have today.
Thanks.
Thanks.